All right, everybody. Welcome to thctrust.org. This is Texm, the trustee over at thctrust.org, and this is the latest outline that I've been working on, and this is relating to discharging charges. Particularly, these are criminal charges in this scenario. Now, the objective of this is to create an outline to assist anybody who is really attempting to discharge criminal charges in their own personal matter. This is not the type of thing that I believe can work for you if you have no comprehension or no understanding of commerce and the system that we are in. But for anybody who's been studying this for some time, you know, the things that I talk about, Form 56s, W8BENs, certification of trust, bonds, the national banking emergency, these concepts aren't going to be new to you. And again, what I'm offering you is just very meticulous research. You'll see I've attempted to cross all T's and dot all I's to the best of my ability. However, I don't have any criminal matter. And this is being, we're creating this to assist someone. And I've been working on this particularly every single day for about 30 days now. So this is the outline, what you see on the screen right now. And if you can, please join thctrust.org. Create yourself a yearly subscription. It's $224, and that'll give you access to all of the templates, all of the research materials that I put together. And I'm trying to keep everything together in a real good format, kind of like you see on the screen here. Not everything is always step by step, but I want to try to make it as step by step as possible, putting specific links in so when you read about a step and then you say, how do I do that? You can click the link and see a template that's going to get you further enough along so you can do exactly what you see in that step. I'm trying to do everything like that. So for $224, you have the yearly subscription on the website, which is actually longer than a year. It gives you all access to the templates, and you usually can always reach me. We have a Telegram group, and all the members have access to it. I spend several hours in there today, and nobody's even, it's not really active. So if you really have, if you're trying to reach me, I'm very reachable. Lastly, before I get started into this, what I want to say is the next template that I'm going to demonstrate for you, I'm going to lay it out just like this, specifically with references and answer many questions about the secured party creditor filing. I'm going to break it down so that you can understand it yourself, make the decision of whether or not you want to complete your secured party creditor filing with your master discharge indemnity bond. I'm going to make it understandable. I'm going to answer all your questions. I'm not going to be evasive. If I don't know the answer, I'll tell you I don't know the answer. For many of you have been rocking with me for several years. I've been studying for, I want to say it's about 13 years now. I think I started around 2009. 2009 or 2008. And I have a lot of great information here. But the secured party creditor, how to do the national filing, where do you file it at? Do I do it in my birth state? No, you don't do it in your birth state. I mean, you could, but that's not your secured party creditor filing with the master discharge indemnity bond. That wouldn't be done in your birth state. But we're going to talk about that. I also do document reviews. It's nothing that I like to do because instead of telling you what was wrong, it's better just to do it right. A lot of time, I'm pretty sure if you went somewhere to have your documents done for you and you truly don't understand what's in them, it's probably not correct, right? Because a lot of people just pay to have things done because they think, well, I don't understand it. It's so complex. Let me pay this guru to do it. The majority of these gurus out here are doing bad paperwork. I don't put myself in that category. So hopefully you see the meticulous nature of what I do. You can check out various different videos and you can see how that is. But with all that being said, let's go through this outline. I try to make it as quick as possible. If you have any questions, drop them below. If you have any comments, suggestions, drop them below. Specifically those of us who've been studying for a long period of time, who are very knowledgeable. I respect your feedback. If you see something in here that needs to be tightened up, let me know what it is. If you have an idea, if you have an idea of what needs to be added to this process to make it stronger, let me know. Right? I am open, but just don't give me any feedback that's not backed up by any type of research or reference. But I really enjoy it when somebody gives constructive feedback, or they add something to this process to make it stronger. You're going to see how strong it already is. And let me, leave your comments below. Let me know if you get anything out of this. Let me know how you like the video. Please like the video if you actually like it. And again, visit www.thctrust.org. Membership is free, but if you want access to all these templates, then make sure you create a subscription, preferably a yearly subscription. Now, in this scenario, the idea here is that we want to discharge the charges in a criminal matter. So I'm going to try to stay just solely on the private side or the equitable side of the discharge, not dealing with the criminal side of the matter. Is it, are your rights being considered? Have you been able to face your accuser? Are these real criminal charges? Are they commercial in nature? I'm just going to stick to the private side, the actual administrative process part of the discharge. So it starts like this. You would start with a FOIA request. So somebody finds themselves in some type of criminal matter that needs to be discharged. You got to start with a FOIA request. At minimum, these are the parties who I am requesting information on. The county itself as an entity, the district attorney and or assistant district attorney, the prosecutor, whoever's bringing the charges. And sometimes there's going to be like a district attorney who's an elected official or appointed for that county, and then he's going to appoint other deputies or assistants. So I want to inquire about the district attorney, the one appointed in the office, and his deputies or assistants, specifically the one that's prosecuting or pushing forward the case. And I want to know specifically about the clerk of the court. And you can also add in here the judge. But I don't, me personally, I would love to hear people's feedback. With the mechanics of discharging a case, I don't really see much need to deal with the judge. The reason is because the clerk of the court is the custodian responsible for taking deposits, monies, bonds, financial instruments. That's all the clerk's duty. The clerk has that authority to deal with people's estate and property in that capacity as a custodian. And it is my belief that it's actually the district attorney or the county attorneys. They're the ones who's required to bond the case. So if there was any bonding going on, even bonds being created, making the defendant the surety of the matter, these financial instruments would be the responsibility of or created in part by the district attorney or the assistant attorney, the one who's bringing the claim. He would have to be the one who's required to make sure it's bonded. And because these officers take constitutional oaths, which in turn are offers, an oath is a pledge. It's an offer of something. So they're starting the contract with the offer. Because they take the constitutional oath, that gives you the position to accept that oath. Remember, the oath is an offer. So when you accept the offer, you form a contract, right? Offer and acceptance. And we want to have a binding contract with them so that we can expect performance, because without no contract, we can't expect them to perform. We can't say that they're breaching their fiduciary duty, and we can't really require them to perform, and the performance we're talking about is discharging the matter without any contract. So we accept the constitutional oath, which is offer and acceptance, to create that binding contract, and then we add the rest of our instructions, etc. So now, I talked about doing a FOIA request, but what is the information that I'm requesting and why? I typically request when it comes from the county, I want their tax ID number and I want any insurance policy that extends coverage to the county. When you do these requests, you're going to find out that counties usually have insurance policies. They have like some government liability policy, and then they may have like an excess liability policy. Sometimes they have about 2 different insurance policies. And other times, when you try to get the insurance policies that extend coverage to the county, they will come back and respond to you and say they are self-insured, which suggests that they basically have enough money and they don't have any outside insurance, meaning you have to bring the claim directly to the group of commissioners or whoever they designate for the self-insurance. They'll always respond and give you this information when you write the right type of request. We're going to look at the request in a second right here. So what else did I want to tell you? Okay, another thing is sometimes they're going to tell you that they're self-insured. This is something that I don't really understand, so I just want to alert you to this. Let me look this up. I want to see if I can find this document. And I'll tell you why in a second. Let's see if I can find it. Okay, check this out, right? This is, I'll point this out to you here. This is like the same information we were just talking about, right? An insurance policy. Here's an example of a FOIA request. Sylvester Moore L. This is when I lived in California. Brendan Duran, Public Information Officer, County Clerk, LA County. This request for information confirms with my right in accordance with California Public Records Act. So every place has a Public Records Act. California Records Act, Public Records Act. They may call it Information Act, Open Records Act. It all depends on the state. But they're called sunshine laws. So if you Google sunshine laws for your state, they'll come up. They'll tell you exactly the codes, where it is. Look it up to make sure it's correct. Then copy and paste, like I copied and pasted this right here. This is the section of the section of the California Public Records Act that talks about the right to access information. Just whatever the act is, however they cite it, just copy it and paste it in a similar letter. This is a request for information pursuant to my right under the Georgia Freedom of Information Act or Texas Public Records Act or California Public Records Acts. And then you paste where it is, you know, the code or the citation. My research indicates that your office may hold one or more of the records subject to this request. The following records and writings are hereby requested. Something simple as that, and then list it out. Copy of an oath of office. Copy of the oath of this person. Copy of the appointment letters for Nancy Alvarez, deputy, for Sherry whoever, which is the clerk, as referenced under California Code section, etc. So here's the thing: when you're looking for something, whether it, I always suggest if you know the custodian, like for example, when you're looking for an oath of office, let's say for a clerk of court, you usually can find that. The way you find out where's the custodian for these things is you got to go through the government code of your state. But when it comes to trying to get the oath of office or a surety bond for a clerk of court, you want to either find out who the Freedom of Information officer is for the county, for the court, or just write the letter there directly. It's always best to get the right person to save yourself time. In these letters, these requests for information, it's always good. You don't see one in this letter. Let me show you another one. But it's always good to ask, if this is not the correct office, please forward this to the correct government office, and in your response, let me know that it has been forwarded. I try to give them that responsibility because they would love to just kick it back and say, oh, it's not us. A very few times they'll do that, but if you put that clause in there asking them to forward it to the correct office if they're incorrect, then a lot of times they'll just go ahead and do that because they have a certain amount of time to give this information back to you, and most of the people take it very serious. There hasn't been any information that I've requested that I haven't been able to get. So trust me, you will be successful. The reason why I came to this particular, because when you look at LA County, I'm just using LA County as example, they'll tell you that to some degree they're self-insured because they really don't want to disclose their actual insurance policies or surety bonds for the county, right? So some places are self-insured, and then some places are self-insured but still have other insurance policies. So this is, where's it at? I lost the page here. This is not the full page. This is the second page of the surety bond for LA County. I'm trying. Where's the first page? Hold on, let's get this right here. Sorry about that, people. Because LA County would tell you, well, anyway, this is their surety bond number, right? Here's their bond number. They'll tell you that they're self-insured. Let me see something here, man. Where's that at? I wanted to show you this. Let's see if I can find it. Well, anyway, as you can see it here, you don't see the declaration page, which is usually the first page of a surety bond. But we can see that this is the bond number. So just know that they have it. And but let me see something, man. I know I have it. I know I got that document. Here it is. See this right here? So this is an idea of what one of these government policies look like. And they will kick it back to you now, because so I'm showing you this because you got to be careful. You got to be very meticulous about what you ask for and read into between the lines when you respond. Because if you don't ask for exactly what you're looking for, or you ask for the wrong thing because really you don't know exactly, you're not being meticulous, then they will respond in such a way as if they don't know what you're talking about, and they'll tell you that they don't have it. Numerous people have been told that LA County doesn't have any surety bond or things of the such, and nobody can find it, and they absolutely do, because you see it right here on the screen, right? It says it. Where does it say what this document is? Modified bond. Requested by LA County. Name, County of Los Angeles. So this is the County of Los Angeles' bond. And that's it, right? So, again, here's another example. So I said we start out by requesting the information. We need this information before we even engage in the discharging the matter. Here's a different example. Let's look at this letter. This is the actual letter that I sent to get this information. This request is made pursuant to the Public Information Act, Texas Government Code, subsection 552.001. If this is not the correct office to process this request, please forward this request to the correct government office and respond accordingly. Please provide a copy of the bond and any policy or self-insurance extending coverage to, for, or on the behalf of John F. Warren in his capacity as the Clerk of Court, and Felicia Petrie in her capacity as District Clerk of Dallas County, including but not limited to the items required by Section 51.101, Section 51.302, and Section 25.0032 of the Texas Government Code. Let me explain what that is real quick. You don't have to go to the extents that I do. I'm just over meticulous with my stuff. You can simply ask for any bond or policy or self-insurance extending coverage to, for, or on behalf of that elected official. When I went as far as to say including but not limited to the items required by Section 51 and 51.3. I actually went into the code and went and dug out the specific sections that says this person is supposed to require to have a bond in this amount and it's supposed to be here. I went real specific on them, right? But what I stated here is clear enough. But ask for these three things: any insurance policy extending coverage, and any surety bond. Because these are two separate things, and if you just ask for one or the other, you may get none or one where there's actually two. So you want to get all that information. Typically, elected officials that have constitutional oaths have surety bonds, and counties typically have insurance policies. They have one or two of them. They have government policies, and even the state has a government policy. So you can request the policy for the state too. But when it's dealing with the criminal matter, I think the surety bond for the prosecuting officer, the surety bond for the clerk of court, who's going to be the registry for depositing your instruments to discharge the case. I think that's basically the policies that you need. All right. Now the other thing is, with these FOIA requests, you can send these requests. Always, to make it easier, you can do some research, or you can call the county and say, who is the FOIA officer? I need to know who the information officer is, right? Or you can Google and find this information. I'm also, I can shoot these requests out for you too. I can get this information. I wouldn't charge you much. If you just feel like it's too much for you and you need me to do it, contact me. I could do that as a service for you. All right. So now you get the other information is the tax ID number. The tax ID number, a lot of times they're not going to want to give you that. Oh, one more thing. Let me point this out to you. So in this same request, you don't see it here. Did I write it in here? No. So the tax ID number, you can also request the tax ID number from the clerk of court. They may or may not provide it. I've had clerks say, sometimes that's not their level. Sometimes they're not familiar with it. But the person where you can get the tax ID number for, and there's a such thing called an IRS Form W-9. When you're doing business with someone and you send them an IRS Form W-9, they're required to send you back their tax ID number. So you can send, most counties have commissioners. That's where I would send the request for the tax ID number. You can send a W-9, and or you can send a open records request similar to that we just discussed, based on the Freedom of Information Act or the Sunshine Laws in that state. So, but usually the commissioners will respond with the tax ID number. You can get it from the Board of Commissioners. Just Google what that is in your county. Or you can look at the county treasurer, the treasury, maybe the comptroller, or the auditor. Counties have these different positions, and usually one of those positions is where you can send the information to get the tax ID number. All right. Now, let's go on to the next step. So this is before we've done anything. We've got their surety bonds. Why? Because when we give our fiduciaries the fiduciary appointment and authorization contract with our surety bond and instructions to discharge the matter, we are relying on their oath and their surety bond as collateral under our binding contract that we formed with them when we accepted their oath of office. We're relying on their surety bond as collateral to make sure that they don't derogate from the laws of the United States government, as well as our fiduciary instructions, which are all in line. They move together, they're consistent, and they don't contradict each other. So what I'm asking him to do and instructing him to do as a fiduciary lines up with the rules, regulations, and laws of the national government under the present financial conditions. And this is why there will be a memorandum of law presented with the surety bond and the instructions and the Form 56 and everything to give them the necessary records to discharge the matter in full acquittance. So once we have all of that information, then we prepare all of our documents. I got to explain this in such an order so that you will understand it. So when we prepare our documents, for example, one of the documents we have Here's a fiduciary appointment and authorization letter. So where is that at? That is going to be, oh, I didn't link this in yet, so I'm going to have to. But in this fiduciary appointment authorization letter, that's where you're going to put the insurance policies and oath of office under the section of the contract that's titled collateral, right? So when the person receives this presentment, when the clerk of the court, which is the registrar for the surety bond, and when the district attorney receives the assignment of the surety bond and they're reading through the paperwork with the instructions in the appointment letter, they're going to see their surety bond number in the paperwork already saying that your oath and your surety bond has been accepted as collateral under this contract and appointment to make sure that you perform. So they're going to understand that. And we have a section on the website where we talk about fiduciary duties and obligations, which will probably shed more light on the situation of why you can expect them to accept or otherwise not reject this fiduciary appointment. And if they accept the appointment, we absolutely expect them to perform. All right. So now, in this particular matter, the surety, or the person being charged with the crime, doesn't necessarily have the capacity to operate in a trust on his own behalf. So this person has created a certification of trust, and somebody else is doing all of this information for them. So let me point this out real quick. Let's click on this certification of trust. Okay. So this is many documents here. One, let's go down to the certification of trust. But here's the certification of trust, right? The undersigned party certify that on April 26, 2023, John A. Doe, the settler, is the person that's going to be charged with the crime, born December 20th, 1963, whose address is whatever, and Thomas Jefferson as trustee, whose mailing address is whatever, entered into a trust agreement whereby the settler has assigned to the trust the legal right of subrogation and surety bond number whatever for the purposes stated herein. So we've assigned rights, and we've assigned estate property in trust. That means this person being charged, right? They're charging this individual, and that individual's estate trust has assigned the legal right and interest to a surety bond and all the legal rights and interest to the ongoing matter. He's put all of this in trust so that the trust can come in on the equitable side with the remedy. So this is just demonstrating the existence of the trust, because to be able to have any type of remedy and equity, and we're going for the discharge of the debt, which is an equitable remedy, you have to be operating in trust. So when you present someone with the certification of trust in the public, that is all you need to validate the existence of that trust. So as I always say, you can Google what a certification of trust is. Specifically, you want to Google the certification of trust for the state of Ohio, so you can see specifically what Ohio requires to be in its certification of trust. The same with California or any other place. So you can make sure you have all of the specifics that need to be in the certification of trust, and then you can add whatever else needs to be in there. I'm going to read through this one real quick. We already set it up. It's a certification of trust. The undersigned party certified that on April 26, 2023, the settlor, John Doe, born whenever, and the trustee, whose mailing address is, etc., entered into a trust agreement whereby the settler had assigned to the trust the legal right of subrogation and the surety bond number 12345 for the purposes stated herein. Whereas the settler is unable to pay a debt due to legal estoppel arising out of the ongoing national emergency as confirmed in Senate Report 93-549, 93rd Congress First Session, and the trustee therein as the subrogee is both able and willing to, let me read that again. The settler is unable to pay the debt due to legal estoppel arising out of an ongoing national emergency as confirmed in the Senate report, and the trustee appointed thereunder, or something, I gotta make that read better, is both able and willing to pay the said debt on behalf of the settler. The terms and mutual agreement of said trust were then and are now as follows. The address for legal service of process of this trust is, you name the address there. John Cruzat has been designated and appointed as fiduciary by this trust with regard to the property transferred herewith and is responsible for accounting of said property and discharging the debt and paying any taxes due. That John Cruzat is the district attorney in this example. Then Tinsley, the assistant district attorney, has been designated and appointed as fiduciary by this trust with regard to the property transferred herewith and is responsible for accounting of said property and discharging the debt and paying any taxes. The trust holds the exclusive right of subrogation, including the right to make a claim or for recovery of losses arising out of the charges against John Alex Doe under account numbers. These are the case numbers right here, claimed by the Dallas County, Texas. The purpose of this trust is to facilitate commerce on behalf of John Alex Doe and to facilitate the redemption of estate, recoupment, recovery, and accounting of principal, reversionary interest, credits, future payments, and or interest owed to the settler's estate, to repay or credit said assets to the registry within the District Court of Dallas County or other fund established for the purposes as set forth in this trust. The trust is not operating for profit, which provision remains in effect until such time as the national emergency has been lifted and the trustee is able to make payments. See the memorandum of law. The trust holds an exclusive right to transact business in the name of John Alex Doe. The trustee holds the power and authority to sign all documents, notices, and contracts for this trust. Said trust has not been revoked, modified, or amended in any manner that would cause the representations caused in this certification to be incorrect. And so you can add on to that, and that is basically, so right now I'm at step 2 here, and we're going to go down all of the documents that are first executed. We didn't do anything yet, but just request bonds, oaths, insurance policies, and now that we got all that information, we're just preparing our presentment. So again, we just looked at a certification of trust. We have to have the certification of trust in there because when we give this bond issue to the clerk, right, we're going to be given a surety bond to discharge these charges. We want to make sure that the clerk can accept this and that they recognize or that they acknowledge the trust is the one bringing this equitable remedy on behalf of the settler and or surety, right? So the certification of trust is how we're going to tie them into that. Because they may want to reject anything else, but we know a certification of trust is a document that's written about in their county, in their code, and they have to accept it in equity or in face value. So we prepare our certification of trust. In the certification of trust, primarily all the things that are required per the local statute that they require in a certification of trust. We also want to demonstrate that the district attorney and or assistant district attorney has been subdelegated the authority as a trustee under the bond issue and or fiduciary under the bond issue, right? So we're subdelegating these people as a trustee and as a fiduciary. We're also going to give them a fiduciary appointment and authorization contract, and we're going to fill out a Form 56 with the IRS to validate and confirm these positions. So here's something, I don't want to confuse you, but I got to explain this a little bit. So remember, if I'm John Doe and I'm the person being charged, and I know that if I try to go in there and operate on my behalf, they're going to try to look at me as an individual and say, you can't operate from the standpoint of the trust because you're the individual surety. So this is why I create a trust. I appoint someone else who's not tied to the matter to be my trustee, at least initially, under this express trust that I'm creating for the specific purpose of discharging this matter. So this is what this certification of trust is. My colleague, who I research with, is going to be my initial trustee under this certification of trust. But further on in the documents, as you'll see, there's also so what I'm saying is my trustee under this express trust is not necessarily the trustee under the bond issue. Because under the bond issue, the trustee is going to be the district attorney or the prosecuting attorney, the one responsible for bringing the charges. I'm going to make a UCC assignment that we're going to see later on. I'm going to assign him the rights and the interest in that property, and I'm going to make him the trustee / fiduciary for the specific bond issue. This is what my appointed trustee is going to do. Why? Because that fiduciary then holds all of the liability for the property, for the bond. He's required to pay the taxes. He's on the hook with the IRS trying to get him tied in, right? So that's going to be clearly spelled out, but I just am stating this because I don't want you to get confused. The liability, the way this thing is being set up, my trustee, my colleague, who's going to facilitate this on my behalf, he's going to do it as an interpleader, or basically as a third party, as my trustee. He's going to do it with the certification of trust. He has the exclusive right to use the trade name of John Alex Doe on my behalf, right? So he's going to execute those authoritative documents that are going to be all in the presentment with the bond issue. I keep using this term, the bond issue, because the bond issue is actually the surety bond that's being presented, the Form 56, the certification of trust, the W8BEN, all of the documents, including the assignment documents and everything that the custodian, which is the clerk of court, and the trustee of the bond, or the fiduciary, which is the district attorney, all of these documents put together is the bond issue. So when I finish getting all of these documents together, and that's what I was going through here, all this stuff in step 2 is the bond issue. The only thing that won't be in there is these documents we use to request to get their insurance policies and all that information. The certification of trust is in there. The completed standard form 28. Let's take a quick look at it. Don't get too wrapped up in this 28. We'll come back to it. I see I'm going to have to do a couple of videos to get into the understanding of this. But just to look at it real briefly, a Form 28 is a government form. It's a GSA form. It's acceptable by all government executive offices as far as I know. And they're acceptable for any bonds that you have to submit to the government. Anywhere where a surety bond is required with government business, instead of a surety bond, you may submit an affidavit in lieu of individual surety. That's what this form is. It's an affidavit it's an affidavit of individual surety, but basically it is a surety bond. It's a part of the surety bond. Remember, this is a bond issue, so this form itself is a part of the bond. So what we have here is John Alex Doe, right? Let's see, anything important to note on here? Name and address of the financial institution submitting the pledge of securities on behalf of the individual surety. I put the name of the trust that has been created. Thomas Jefferson Trustee under agreement with John Alex Doe, dated 4/26/23, doing business as John Alex Doe. Right? So that this is the same trust that's referenced on the certification of trust. I have the way that we name this is John Doe, the trustee. That's the first trustee that I appointed, my colleague, under agreement with me, John Doe, who's the settlor and the grantor and the surety under this matter, dated 4/26/2023. This is the date that we established the trust, and then I add the doing business as John Alex Doe. This is called a trust registration statement. I'm not going to go into that here because I went over it many times in numerous different videos. If you want to know what that is, Google FS0049 questions and answers about trust. It's a treasury document. And so we use this trust registration statement here. Now let's look at section 7 on the affidavit of individual surety. Section 7 says, the following is a true representation of the assets I have pledged to the United States in support of the attached bond. So the only thing I'm using this form for, this standard form 28, which is an affidavit in individual surety, I'm using this form to attach and present the assets that I am pledging in support of this bond issue, because securities are backed up by assets. A lot of people say the birth certificate is a security. I tell you, no, it's not a security, but it is an asset that may be bundled or titled in or backing a security. For example, when people do their CUSIP research and they get this CUSIP number and they say, oh, that's my CUSIP number. That's not your CUSIP number. That is a CUSIP number. But what the research indicates is that you have assets bundled in that security. Now, here's something else. I'm just throwing this stuff out here quick because it's a lot of information, I know. When you look at, let me read this one more time. The following is a true representation of the assets I have pledged to the United States in support of the attached bond. So in this case, the asset that I'm pledging is the certificate of live birth with the full faith and credit of the United States attached to it. Why do I say it's a credit asset? Well, one, because it doesn't have a CUSIP number. Many people says there's a CUSIP number on a birth certificate. There's not. Don't be confused with people telling you there's a CUSIP number on a birth certificate. If it is, have them identify it. And then when they identify it, look up the definition of CUSIP number and see if that's what that number is. More than likely, they're talking about a state filing number, which is not a CUSIP number, or they're talking about a serial number. Because a lot of these, like on the back of the Social Security card and oftentimes on the back of birth certificates, but not always on the back, you'll see a red number. Well, those numbers usually are serial numbers. And I know because if I have ordered multiple certificates and I've seen those serial numbers increase. CUSIP numbers don't increase sequentially. Serial numbers do. And as you already know, serial numbers are used to identify assets, not securities. CUSIP numbers may be used to identify securities. Serial numbers are used to identify assets. They're sequential numbers. Even, for example, when you look at your checks, they have sequential numbers, 1, 2, 3, and they don't have any specific value. The value of your check depends on the transaction in which you negotiated. And this is the same understanding that I have of the credit assets that come from your estate. And I'm talking about these certificates of live birth, right? That in this particular example, we are pledging as an asset in support of the attached bond. Now let me read this right here. Credit asset serial number 0000. I would actually get the serial number off of the certificate of live birth. State file number, etc., identifying the certificate of live birth. With the United States full faith and credit guarantee, serial number, whatever, right? So what am I talking about there? Anyone who's went and got the full faith and credit guarantee on their birth certificate. I'm talking about authenticating your birth certificate with the Department of State of the United States of America. Well, if you look at that certificate, there is also a serial number at the top of that certificate. It's not a CUSIP number. Those numbers also can increase sequentially, if that's a word. Meaning if you sent 3 documents to get authenticated and they authenticated them in order, the number at the top of the United States certificate, that beige certificate, it will change every time. So those are serial numbers. And the thing to pay attention to is that certificate is the United States putting their full faith and credit guarantee on the asset that they put it on, or the document, or whatever. So they're putting this full faith and credit guarantee directly on top of our credit asset, which we're calling the birth certificate. But we're calling a credit asset because they're also printed on banknote paper. Many of you know, if you don't know, now you know, the certificates of live birth are printed on banknote paper. The ones in California say banknote paper. And why did I give you the example of the check? Because we have to flip this credit asset over on the back and transfer it. We have to write an endorsement on the back, transferring the value, conveying it, pledging it as an asset for the bond issue. So now we have a credit asset and we're pledging it with the full faith and credit of our estate, and that is actually guaranteed with a specific guarantee and certificate number of the full faith and credit of the United States. Does that make sense to everybody? I hope that makes sense. If you haven't seen, many of you that have been in the game for a while, you know about authenticating birth records. So you don't have to see what I'm talking about to understand. So now you know what to look for. Full faith and credit guarantee number, the number at the top of the United States full faith and credit certificate. So you know on your certificate of live birth there's a serial number, not a CUSIP number, right? So let's read this again, knowing that the certificate of live birth is a credit asset, and see if this makes more sense. Credit asset serial number 123, state file number 1234, with the United States full faith and credit guarantee serial number 123 affixed thereto, for the par value of $10 million. That is the par value that I am negotiating it for in this transaction. That's why it has the value. It's almost as if somebody said, hey, what you going to give me for this car? It's worth $10,000. And I go home and I grab $10,000 worth of assets, right? They don't have any specific price of the assets that I grab. But if I'm negotiating with them, this is a contract, right? So I'm saying I'm pledging this collateral for, this is worth the $10,000 that you're asking for. That's the position that I'm taking. There's no evidence that it's worth $10,000, $10 million. That's the value that I place on it. Now, the person who's charging me, they can say, okay, well, I'm willing to accept that collateral, or they can say, the collateral's insufficient. But either way, they got to state it in writing. They got to state something, and this is what we're going for with this bond issue. We're pledging collateral, which we believe is eligible collateral. And furthermore, we believe they have to take this collateral because it's backed up by the full faith and credit of the United States government. And this will be supported by the memorandum of laws that is attached. So I hereby transfer to said fiduciary the authority and power to pay, adjust the accounting, and otherwise discharge the obligation using the instruments, interest, and property conveyed herewith in accordance with Section 5B2 of the Trading with the Enemy Act of October 6, 1917, 40 Stat 4011, requiring the discharge in full acquittance, and in accord with Section 3113A and 3113E2 of Public Law 97-258, etc., as a gift of the United States, as a gift to reduce the public debt of the United States. So the purpose and objective of this bond issue is twofold. One is to discharge a debt that you're unable to pay due to the national emergency, which is backed up by the memorandum of law, and to pledge the credit asset in a manner to reduce the debt of the United States, which is also something you have a right to do, and it's something backed up by the federal law. These are the purposes that we believe will bind the fiduciary and obligate their performance. So that is the standard Form 28, and I just kind of lightly went over it. This will be part of the bond issue. So we have the certification of trust. We kind of went over that. Went over the standard Form 28, which is part of the bond issue. Then we have the actual bond. Why is the bond not here? I almost swore I put that bond in here. We'll pull up the bond issue here. You can click on the bond and that'll come up. I just don't have it tied in right now. Then we'll also include, so we looked at the Form 28. Let me tell you what's going to be attached to the Form 28. The Form 28 is actually going to have the certificate of live birth with the full faith and credit attached to it, right? Because what did they say right here in box 7? And on the old Form 28, on the old standard Form 28, they used to ask you to attach the certificate. But now they just say, the following is a true representation of the assets I have pledged to the United States. So you have to identify those assets. But like I said before, they used to ask you for the certificate. And they say list any CUSIP numbers and the par face value of each security. That's in parentheses. But as I said, we're not submitting any security. We're submitting a credit asset to back the security. So we're submitting assets in support of the bond issue. How do we get back over there? All right. So with the GSA form, You describe the credit asset, then you attach the credit asset, which is the full faith and credit certificate of live birth, which is also going to be attached to a surety bond, a basically surety bond that I created on bond paper. And we'll see that next time. But don't get wrapped up. I'm not showing it because it's basic. It's not, the things I'm showing is what's critical. And then we also have a memorandum of lawful obligations of the United States of America. Let's look at that real quick. So with these presentments and this memorandum, you see it on the screen here, but by the time you actually access this, if you have a membership, it's going to be further in depth. Right here, you see about a page and a half worth of laws. What these laws are going to demonstrate, and like I said, there's more now. We start with the obligations of the United States of America as far as just general obligations that are necessary. I need to get the most up-to-date one. Let me find it real quick. Let's see. Come on, where are we at? All right. Let me put this on the screen here. This is the memorandum of law. Where is it at here? It's not there. All right, this looks like it right here. This is the Memorandum of Lawful Obligations of the United States. We go and talk about the national emergency, and I break down, here's presidential proclamations, acts of Congress, congressional records, HJR 192 is in there, the Trading with the Enemy Act is in there, constitutional provisions that are relative, no state shall make or enforce any law which shall abridge the privileges and immunities of citizens of the United States. This is not the most up-to-date memorandum of law, but you will have it. I also go into eligible obligations of the United States in lieu of surety bonds. These laws down here are going to support the use of the certificate of live birth with the full faith and credit guarantee of the United States being pledged as eligible collateral for the bond issue. That's what this section of laws down here is going to support. So I would really encourage you to really understand this process that I'm trying to demonstrate is read all those read the memorandum of law that's going to be included. So there's going to be a certification of trust, the Form 28, we went over that, the bond instrument, certificate of live birth with the full faith and credit with the full faith and credit of the United States, certificate attached, and an endorsement on the back. The memorandum of lawful obligations of the United States has to be in here. We just kind of looked at that memorandum of law. It's going to be 2 pages. And then we have the fiduciary appointment and authorization letter. I went over that in other videos. It's kind of standard. I'm going to go over it again. I'm going to have to make another video about this, but in that, it's going to spell out, it's going to give them the power, spell out what they're required to do, demonstrate that they have been appointed as the fiduciary. It's going to What else? But anyway, that has to be in there. It's also going to include their insurance policies and bond information, letting them know that it has been accepted as collateral so that they don't derogate. And then there's going to be a W8BEN demonstrating that the John Alex Doe is the beneficiary on the account. We're going to throw that W8BEN in there. Then we're going to throw an IRS Form 56 in there. Here's the thing about the IRS Form 56. If I'm John Doe, the person and the charges are being charged against me, I also create this trust instrument as we stated that we did, and we created this certification of trust, transferring the surety bond and the right to subrogation of all right and interest in the charges. We transfer that. We put all of that in the trust. And let me explain this real quick. Sorry for going back and over. If you notice here, step 2 says file the UCC financing statement on the bond issue. All of these documents is the bond issue. So once all of these are created, a UCC1 will be filed. And when the fiduciary, which is the district attorney, the one who's responsible for discharging the charges, when he receives this bond and everything, he's not going to actually receive the bond. He's going to receive a fiduciary appointment, an authorization, and a UCC3 assigning him the rights and interest in the entire bond issue. So the first UCC1 filing is just you put the whole bond together, you file the UCC1 on the bond, then you send the bond to the clerk to be deposited in the registry of the clerk. In the registry of the court. The clerk is not the fiduciary under the bond. The clerk is not the trustee under the bond. The clerk of court is only the custodian of the bond. Only thing they're doing is depositing it in the registry, the entire issue. So the fiduciary appointment that the attorney needs to see, all of these documents are all behind the bond. They're with the bond. Once that's recorded, and first you record the UCC1, you got the financing statement, you sent it, registered mail to the clerk of court for deposit. The bond has been deposited. You have those information. Now you send the fiduciary appointment and authorization letter to the attorney or the district attorney who has been appointed the fiduciary. And of course, a copy of that letter is going to also be with the bond as part of the bond issue. So what you're going to send the fiduciary is a UCC3 assignment with his name so that he knows he has been named the assignee. You're going to probably send them the Form 56 for them to sign. Don't sign the Form 56 on behalf of the fiduciary that you appointed. Just complete it and send it to them for their convenience so they can sign it. You will see in the cover letter to the fiduciary. All these things, again, you see some of these PDFs. These are all going to be filled in when you have access to this on the website. You're going to see in the cover letter to the fiduciary, he's been appointed as fiduciary. He's been given the Form 56, and we let him know in his instructions. He is required to let the IRS know within 10 days of his receipt of the property that he has been appointed fiduciary. We didn't make that up. The IRS requires him to do that. And therefore, we have enclosed a completed Form 56 for his signature for that purpose. So we do that because if he doesn't let the IRS know, then we can let the IRS know in 10 days that that fiduciary relationship has been established. We have to let the IRS know that. They want to know that because the fiduciary is responsible for paying the taxes on the matter if there are any taxes. So I hope that's understood. Now, I'm going to wrap this up because, man, this was way longer than I thought, and I really didn't get in depth in it, but I kind of gave it a good overview, I think. After you complete all the instruments, certification of trust, Form 28, you have the full faith and credit attached to your birth certificate, and you flip it over on the back and you write out the endorsement to the United States Treasury on the back of your certificate of live birth. Then you put the fiduciary appointment authorization letter in there, W8BEN, IRS Form 56. You get all that stuff together once it's executed, certifications of trust included, and what's the other one? The power of attorney. I didn't have that in here, but there's also a power of attorney. That'll be added in here. Once you execute all those documents, make a colorful copy of them. A true copy, but make it a color copy of everything. Then you go file the UCC-1. You make a copy because when you file the UCC-1, you give them the originals. They take all the originals, including the original bond, and they run a tax assessment on the bond, right? They're doing a work order. They're carrying out this whole process on the bond. It takes time. It may take about 3 weeks or longer. I don't remember exactly how long it takes for them to process this type of national UCC filing. This is not a regular UCC filing we're talking about. It's a national UCC filing. I didn't get into that in this video, but I'll instruct or I'll get further into how you make sure and do a national UCC filing in the next video where I talk about this topic. We're going to go further in detail in this light overwork that we're doing right here. So you create a copy of everything because you're going to give them the originals. They're going to take the original bonds. They're going to start the work order process on it. But on your copy, they will stamp it. They will give you your official UCC filing number, and your true copy is just as good as the original that's being processed. So now that you have your true copy and the original is being processed. Now remember, whenever you file a UCC, they ask you for the address, the acknowledgement address of where you want them to send the completed filing. This is where they're going to send back your original surety bond and all your original documents, in this case of this national filing. So we're going to make sure that when we file the UCC-1 on this and they take the originals, that we tell them to send the acknowledgement or all the original documentation. We want them to send that back to the bond custodian, which is the clerk of court. Now the clerk is going to already know it's coming because when we got that copy of our process, that is the actual bond issue that we're going to register to the clerk. So what we're going to send to the clerk as far as the bond is we're going to send them the true copy of the UCC-1 financing statement that they just gave us and the true copy of all the records that have been filed, the financial records, because the true copies are just as good as the original. So we send that to the clerk via notary presentment. And when I say notary presentment, all you got to do is take all those records, put them together, and then have your notary mail them to the clerk and provide you with a certificate of mailing listing the contents that have been mailed. That's all you have to do with that. You don't have to go any further with that. And now the clerk has received the bond issue. So what I would suggest at this point is you wait the appropriate amount of time until they're done processing the UCC, right? How would you know? I'm not really sure because when they, like I said, when you give them the originals and they stamp your true copy, they're going to give you the UCC filing number. But you know that your UCC-1 is filed. You know that the custodian received the bond issue. And let's look at this real quick. This is what it's going to look like. Where are we at here? Kind of looked at it earlier. So, right, this is the this is what the clerk will receive. So the first document that it was received is the UCC-1 financing statement, right? And then behind the financing statement, they will receive this. This represents everything. You know, here's a registry deposit to the clerk. This is the actual form that you would use to make a deposit in the registry of the court of some type of security. So this is the form that we're using to instruct the court that this is this presentment is a registry deposit of a surety bond issue for the court's registry. So we kind of put their caption, we put the court's format here. So that'll be the registry deposit, the certification of trust. Obviously, this will be executed. The memorandum of lawful obligations of the United States. That's the page-and-a-half memorandum of law. The power of attorney demonstrating that the trustee, my colleague that I appointed as my trustee, has the authority and capacity to act in this matter as my attorney in fact, and he has the right to subdelegate other trustees because he's going to subdelegate the fiduciaries as trustees under the bond issue. So the power of attorney is going to be in there. The W-8 is going to be in there. The Form 56s, all the documents are going to be behind the bond issue. I mean, they're going to all be behind the UCC-1 that was already filed. But I like to say this is most important. And this says, I, Thomas Jefferson, the undersigned attorney in fact for John Doe, right? That's John Doe is the person being charged. Thomas Jefferson is his attorney in fact, and he has included the certification of trust and the power of attorney with this bond issue. By the authority entrusted in me, tender this eligible obligation as a surety bond to the clerk for deposit into the registry of the court for acceptance and discharge and full acquittance of the total penal sums and charges arising out of the above case numbers, and to reduce the public debt of the United States by gifting the remaining proceeds to the United States government, something like that. Now, I created this cover page, but what I did is, let me Google this real quick so you can see what I did. Registry, surety bond registry deposit, Dallas court. So I do Google things like this, and then this is the, let's see, is this it? They have a registry deposit form. Let's Google like this. Dallas County registry deposit. There it is. So this is their standard form, what they use. You notice I modified it and made what I'm doing a little bit differently, but this is what they usually use. This is their form to deposit funds into the registry of the court. So this is the critical information they're going to need: case number, bond type, case style, tax ID number, or social security number. And I actually did some research, so I understand why they're asking for all of this. So I made sure with my cover page I included everything that they would need to process or make a book entry, because that's what's really going on. I'm just giving them commercial paper. When I'm saying make this registry deposit, I'm saying this paper is valid enough for you to write the money on the books, make the book entry. So I'm providing them all the information they need about this bond, surety bond type, the par value. This is what I've pledged the assets for, the amount of $10,000, CUSIP number. In this particular case, there's no CUSIP number. But if I did the CUSIP research on my full faith and credit certificate of live birth, I would put that CUSIP number right here. It's not my CUSIP number per se, but it is a CUSIP number of a security where my assets are titled and bundled. So I would put the CUSIP number here. The principal is the John Alex Doe. The tax ID number. Remember, you're bringing an equitable remedy on behalf of a surety who's in an individual capacity. They're using his social. So once you establish the trust and you issue the certification of trust, your colleague who you've appointed as trustee can contact the IRS and apply for a tax ID number for that trust. And then you can put that tax ID number here, right? Attorney in fact, you can fill that out. Thomas Jefferson trustee under agreement with John Alex Doe dated 4/26/23. That's the attorney in fact. He's attorney in fact in his capacity as a trustee. That really can't be argued because we included an executed power of attorney. The surety, the guarantor, the obligee, the trustee, the custodian, we name in all these positions the registration number, authorization. I have so these first laws that I cited up here, and all this stuff is in the Memorandum of Lawful Obligations, but these first are just references that demonstrate why the certificate of live birth is an eligible asset to pledge as collateral to back the surety bond issue. These next authorizations deal with the discharge under the National Emergency Trading with the Enemy Act, the requirement to discharge in full acquittance. And this last one is for the purpose of any remaining proceeds to be used to reduce the debt of the United States of America, which again, all of these are federal obligations that are incumbent upon the fiduciary. Remember, these fiduciaries, these elected officers in the county, they swear to support and defend the Constitution of the United States of America. That's not a local government thing. That's a national government thing. And again, there's a national emergency, so we're wanting them to perform in accordance with the national emergency. So that is the bond issue information. And again, once all of that's executed, you put it on deposit with the clerk. And then once we know that they have it, then we have to assign via the UCC3, and an assignment, fiduciary appointment and authorization, Form 56, to the district attorney, giving him the property and requiring him to do the discharge in full acquittance. So that's kind of where we're at with it right now. Man, this was longer than I thought. I don't know if I covered it adequately. Is there a lot of questions out there? Please leave your questions and comments below. I'm going to touch on this again. We'll just call this video 1. And again, for members of thctrust.org, everything that I discussed, things that you've seen and what you haven't seen, everything in this outline has already been prepared. It will be linked into this, so you'll have access to it. So again, the website is www.thctrust.org. You can create a free membership, and I do coaching sessions. They're $75 per session. We do document reviews, and as I stated, after this outline, the next outline I'm going to prepare is the secured party creditor outline to show you how to do the national filing with your master discharge indemnity bond, etc., etc. Anyway, thank you for watching, people. I'm out.